So my name is Kai-Ching. I'm a partner at Littler and Mendelson. Littler is the nation's largest employment law firm, and I've been there for about 10 years. My practice is a combination of single plaintiff discrimination litigation and class action litigation.
And I'm Lisa Horgan. I'm an associate with Littler Mendelson. I've been there about 8 years now, and in the past couple of years, my practice has become a lot of advice and counsel work, which means that I spend most of my day talking to employers just like you guys about how to handle kind of day-to-day employment issues, as well as some litigation.
Right. And we are here to talk today about equal pay, gender equality, and the influence of the Trump administration on employment law. So here are photos. We can skip over that since we're here in person with you guys. Okay. Things we're talking about today is equal pay, gender equality, the increased focus on LGBT rights, fair pay laws, the new Trump administration, what's in store for employers. And then we wanted to talk about ADA leave and accommodation because this is an area that constantly where employers do constantly have issues. And we see litigation again and again. And honestly, it's because I think of honest mistakes made on the part of the employer, which result in, at least in California, in a lot of liability, high dollar amounts of liability. Mm-hmm. Okay. So for the LGBT rights, just in April, I wanted to talk about this decision. It's called Hively versus Ivy Tech Community College. And this was in the Seventh Circuit. And basically, in April 2017, the Seventh Circuit became the first federal court of appeals to find that Title VII of the Civil Rights Act prohibits sexual orientation discrimination in employment. And Title VII is a federal statute that prohibits discrimination. It makes it unlawful for employers to discriminate based on race, color, religion, sex, or national origin. It was passed back in 1964. And Hively, the facts of the case are very simple. She was an openly gay adjunct professor, and she alleged she was denied full-time employment because of her sexual orientation. Now, the situation is that it is so well established that sexual orientation is not covered by Title VII that when, all right, Littler, we represent employers. So if we had an employee who filed a lawsuit saying I was discriminated based on sexual orientation under Title VII, we would be like, oh, no brainer. That's an easy win. I'll get a first year to write a motion to dismiss and get this thing kicked out, right? This is just, it is so simple and it's so basic. Title VII doesn't protect under this. And there is no circuit court in the country that provides so that sexual orientation is protected under Title VII.
As a brief aside for the California folks in the room, California law does protect for sexual orientation.
Right.
So this is federal law as applies to most of the other states. California law, at least in the recent history, has always protected sexual orientation.
Right. And there are actually something like 26 out of 50 states do have state law that protects against sexual orientation discrimination, but federal law never has. And so, for example, in March 2017, there was a 11th Circuit decision where they just reaffirmed, yeah, Title VII doesn't protect against sexual orientation discrimination. So that case is dismissed. So the legal procedure, I just want to briefly mention this. And normally for non-lawyers, talking about legal procedure is about as interesting as watching paint dry. But in this case, it's awesome. So So Hively, she files the complaint in federal court. The trial court, all right, so defendant, employer, they move to dismiss, right? Title VII doesn't protect against sexual orientation discrimination. The trial court dismisses it. It's absolutely like correct under the precedent of the Seventh Circuit. There's no protection. Plaintiff Hively, she appealed. Seventh Circuit, there's a panel of 3 judges, and they affirm the dismissal. They've got something like 6 prior decisions from the year 2000 that have all held that Title VII offers no protection from sexual orientation discrimination. Right, so they've got 16 years of precedent. They've got 6 decisions. They're like, all right, this case, it's dismissed. But then it goes to an en banc panel. That means all 11 judges of the Seventh Circuit have to review the decision, and the Seventh Circuit reverses itself. It reverses 16, 17 years of precedent reverses all of the prior Seventh Circuit decisions, and it comes to the conclusion that Title VII does protect against sexual orientation discrimination. So, and they voted that basically on it was an 8-3 vote. And so that is shocking. I mean, that's the kind of thing that, never happens. The Seventh Circuit decision, they basically said this discrimination based on sexual orientation is a form of sex discrimination. And they used 2 decisions to do that. One was the Supreme Court decision called Price-Waterhouse and Hopkins. That determined that sex discrimination included sex stereotyping. And the Price-Waterhouse v. Hopkins case was a case where a female was up for partnership within Price-Waterhouse. She was denied, and the Supreme Court, they basically said, look, the reason in part that she was denied is because she didn't behave the way traditionally people expect women to behave. She didn't dress right, she didn't wear makeup, she didn't have any fashion sense, and her personality was too aggressive. And so they said that the sexual stereotype, that she wasn't conforming with sexual stereotype, that was a form of sex discrimination. So Hively, in this case, they basically said it is the ultimate case of failure to conform with the female stereotype in the fact that Hively was married to a woman instead of a man. The other hook that the Seventh Circuit used was called associational discrimination. And they relied on the Loving versus Virginia case, which people may be familiar with because of the recent movie. Sorry. So Loving versus Virginia was a case that challenged Virginia's anti-miscegenation statute, right? And basically the Supreme Court held in that case that where the government discriminates against an individual for associating against an individual of a different race, that's discrimination based on race. And so by discriminating against Hively for her association with other women, Title VII prohibits that type of discrimination. These are a couple pretty amazing quotes from the cases. The first one, the judge in the district court decision that dismissed the case, she made the point that we allow 2 women or 2 men to marry over the weekend, but then when they come in to work on Monday, we allow employers to terminate them for that. Right? That makes no sense. The second quote is from Judge Posner, and I won't read it out loud, but it's really interesting to me because when I was in law school, we read a lot of Judge Posner opinions, and Posner was always considered a very conservative judge. Like if someone was going to nominate Posner to the Supreme Court, it wouldn't be a Democratic administration. It would definitely be a Republican administration. And he absolutely stands by the fact that you have to interpret laws given what we know now. You don't look at the old original intent of the law, right? Which is something that is a constant issue with the Supreme Court, right? How do we look at the law? How do we interpret the law? Okay, so what does this mean for employers? The point is that right now within the Seventh Circuit, Title VII does protect from sexual orientation discrimination. That's in Illinois, Indiana, and Wisconsin. Arguably the rest of the country, it's still legal to discriminate based on sexual orientation, or basically in the rest of the country, Title VII doesn't protect from sexual orientation discrimination other than those 3 states. Okay. However, there's something like, I think there's something like 26 out of the 50 states do have state-specific laws that protect against sexual orientation discrimination on some level. Some just protect government employees, and some protect just sexual orientation. Some also protect discrimination based on gender identity. Not all states do that, but so the point is that if you have operations in different states, check your policies and make sure that you're in compliance with whatever your local state law is. Okay. So this is the point. All right. I just want to give a shout out to Fox News. I'm going to talk about this briefly because this is kind of interesting. So in April, the thing that I found was so interesting about this was the New York Times broke the story in April that Bill O'Reilly and Fox had settled about $13 million with 5 different women. And the deal is actually a lot of these lawsuits were really old. Like there was a $9 million settlement back in 2004. Okay, I mean that is what 13 years ago. It's kind of like who cares, right? I mean it was so old. I mean I shouldn't say that, but and then one of them, actually an even older one, it wasn't harassment based on sex. It was just he was abusive towards an intern. And I think of media, the industry, as a place where interns go to be abused. It's like by definition, you're working in an abusive environment.
Shouldn't be,
but it is, right? I mean, okay. But after the New York Times broke the story, within 2 weeks, 50 different advertisers had pulled their advertising from the O'Reilly factor. The very first one was Mercedes-Benz. The second one was like Hyundai. And then it went on from there. It's all these international, it's not even like Fortune 500, it's like international, global, huge companies. They all pulled their advertising. Prior to this, Bill O'Reilly was somebody who made something like $18 million a year. Fox, his show was responsible for generating something like $450 million in advertising every year of revenue for Fox. And within 2 weeks of the New York Times breaking this story, Fox released him. Okay, so what is the significance of Fox News? I think in part it's actually the amazingness of the free press, but for employers, it's incredibly important to uniformly enforce your anti-harassment policy. No one is too important within your organization that they are immune from the anti-harassment policy. And keep in mind that for employers, the argument that this person is too valuable for us to properly investigate or discipline, that sets you up for punitive damages when it comes to a jury trial. In places like California, punitive damages are not capped under the state anti-discrimination or anti-sexual harassment laws. Title VII caps punitive damages, but in California, your punitive damages are not capped.
And if you're not familiar, punitive damages are basically damages that the jury can award just to punish you for bad acts. And so they don't necessarily need to be tied to actual damage that the person has suffered. And so someone may have just been out of work for 6 months, but they could get millions and millions of dollars in punitive damages.
Right, especially if you have somebody who's portrayed as a serial harasser that the management just lets run amok within the organization. Okay. You want to ensure that leadership is setting a clear example for the rest of the organization. One of the theories is that O'Reilly got away with what he did because Roger Ailes was the head of Fox. So Mr. Ailes probably acted as an enabler, or he couldn't discipline O'Reilly because he himself was a serial sexual harasser. And then the third point I wanted to raise is that settlement agreements with confidentiality provisions. So all these women signed confidentiality agreements with Fox, right? So they were not able to talk about their claims against O'Reilly or the amounts of the settlement. But the New York Times, they did something like 6 months of digging, and they got all this information out. One of the things that I always do in my settlement agreements is I try to almost always have what's called a liquidated damages provision. I make all my settlement agreements confidential to the extent that I can, and then I have a liquidated damages provision, which is basically a penalty amount, like a set penalty amount based, it's kind of tied to, it's proportional to the amount of the settlement. It says if you breach the confidentiality provision of this agreement, you're gonna have to pay, let's say X dollars, like $10,000 or $2,000 or $5,000. The reality of that is that it's actually not very enforceable. I've had in-house counsel complain to me, well, Kai, yeah, we have a liquidated damages provision for like $5,000, but I have to pay you more than $5,000 to get that money, and the person probably isn't even going to have the money. So it's just like this. It's this provision you put in there. It's supposed to be so effective, but in reality, in real life, it's not actually that effective. So it's something to kind of keep in mind about your settlement agreements. Okay, I want to just mention North Carolina. So in 2016, so we're off of Fox News. We're on Whose Bathroom Is It? North Carolina, 2016, they signed the HB2 bill, which banned people from using public bathrooms that don't correspond with their biological sex, as listed on their birth certificates. And so economists, there was a huge sort of corporate pushback on this bill, which has been highly publicized. I think people have probably seen in the news that companies like PayPal, companies like Deutsche Bank, Adidas, I think also even Bank of America that's based in North Carolina, a lot of companies decided to stop or put the brakes on expansion within North Carolina because of this bill, because this bill was so unpopular. And so the estimated cost out to 2028 was that this bill would cost North Carolina $3.7 billion in sort of lost corporate opportunity. The estimate for just for the year through 2017 was over $500 million of lost income to the state of North Carolina. So as a result, in March 2017, North Carolina, they repealed part of it. They repealed the rules about who can use which restroom, right? They retained other features. They still allows for discrimination against transgender people. And they prevent local governments from passing or amending any of their own non-discrimination ordinances. So cities like Charlotte, who want to be more liberal, they can't pass a local ordinance kind of protecting their employees more related to private or public accommodation. But I thought it was very interesting to see, sort of like the Fox News thing where all the corporations pulled their advertising in now they're influencing sort of state legislation. Okay. Finally, this is just a point that California law already prohibits discrimination against transgender people, including any restrictions on the use of public restrooms. Okay.
All right, so now we're going to talk about equal pay and pay discrimination. And I'll start with a little bit of an overview of federal law, and then I will delve into some of the ways that state laws have been passing states have been passing even more strict laws in this area. So there's two main federal laws. There's the Equal Pay Act and Title VII, which I'll talk about next. And Equal Pay Act requires that you provide equal pay regardless of sex. And in terms of job comparison, it asks that you look at substantially equal skill, effort, and responsibility and working conditions within the same facility. That's one of the major kind of Equal Pay Act limitations, is that you're looking at employees who work in the same physical location, or in some cases, if they work in different locations under the same manager. This is not a discrimination law. It requires no discriminatory intent. It just looks at what is the result. Are people actually being paid differently based on their sex, regardless of why that is? And then you have to be able to explain the entire wage differential with one of these defenses. So differences in pay between employees of different gender under the Equal Pay Act are okay if they're pursuant to a seniority system, a merit system, or a system that measures earnings by quality or quantity of production. And then the most important one, which didn't make it on this slide when we were putting it together, is a factor other than sex. Just any factor other than sex. It doesn't even necessarily have to be a very strong one. If you say, I pay people whose names start with A more than people whose names start with B, and there's no, disproportionate in terms of men and women who start with A and start with B, then as long as that's actually the reason that you pay people differently under the Equal Pay Act, that would be fine. Title VII, Kai mentioned, is an anti-discrimination law. And obviously, because Kai talked about it, it's a much broader law. It's not necessarily just to do with equal pay. It prohibits discrimination based on sex, based on race, based on all of the other different protected categories in any way, including pay. But for Title VII, someone has to prove discriminatory intent or a disparate impact of a neutral law. So as I just mentioned, this is an anti-discrimination law. And one very important thing that I want everyone to take away from this session, not just to do with equal pay, but it's related to equal pay because a lot of these laws have provisions relating to this, is pay secrecy is no longer allowed in most states and most jurisdictions. I think that it's very common for employers to have policies where they prohibit employees from discussing their pay with other employees. That is no longer permitted because under California law, New York law, Minnesota, Oregon, Many states explicitly prohibit it, and more recently, the National Labor Relations Board has found that preventing employees from discussing their pay with other employees is a violation of the National Labor Relations Act. And that applies to any non-supervisor employee. It's not just unionized workforces. And then in addition, there is the pay transparency rule for federal contractors, which may or may not apply to your organization, but is just another indication of how, in all of these jurisdictions, more and more agencies are taking a look at these pay transparency and pay secrecy requirements and requiring that employers allow their employees to discuss pay. So we talked about federal law, and I just want to touch briefly on the state laws, because everybody is always subject to federal laws as well as state laws. And so several states have recently taken on the pay equity issue, and that's California, New York, Maryland, Massachusetts. And there are other states with equal pay laws proposed. That's Ohio, Illinois, Pennsylvania. I believe that Puerto Rico is also proposing something along those lines. So first I'll touch on the California Equal Pay Act. And I'll talk mostly about this, but just be aware that the other states that have passed equal pay requirements are very similar to California. And there are two major ways that it differs from the federal law. So first, it differs in the types of jobs that it will compare. As I mentioned, for federal law, it's only interested in employees working at the same facility. California says it doesn't matter where they work. All that matters is if they're performing substantially similar work, which is so a composite of skill, effort, responsibility, and performed under similar work conditions. Now, what does that actually mean? No one really knows yet because this is a new law. So it's possible that this will be interpreted very, very broadly. And then the second difference is that where the Equal Pay Act says any factor other than sex is okay, California says it needs to be a bona fide factor other than sex. And what it means when it says bona fide factor is that it has to be not based on or derived from a sex-based differential. It has to be job-related, and it needs to be consistent with business necessity. So what it means for something to be job-related is that you can't just say, well, I have a couple of welders, right? But one of them has a PhD, so I'm going to pay that person more. The California would say, well, tell me how that PhD actually helps them in performing their job. And if it doesn't, then that's not a job-related justification for paying that person differently. And then in terms of consistent with the business necessity, California employers have to be able to show that there is no other method that would allow them to accomplish whatever business necessity is driving this differential. And then on the not based or derived on a sex-based differential, that means that prior salary can no longer be used as a justification because employers can't guarantee that that prior salary wasn't itself being driven by a sex-based differential.
So one thing I want to say about the California Equal Pay Act, it was in the news. So Salesforce.com, when the California Equal Pay Act first came out, Salesforce.com, they did an internal audit, and they think they was very public about it, and they paid something like $3 million to get everybody up to parity. And then 2 years later, now they did another audit, and they actually had to do another like $3 million adjustment of their payroll to make everybody on par. And they explained it as they had done a lot of acquisitions, and so there were employees from acquired target companies who maybe when the target companies hadn't done an audit under the California Equal Pay Act at the time, and so they were readjusting all those salaries. But it is something that had to, it's encouraged to do periodic audits of your payroll to make sure that it's all on parity.
Yep, and I'll touch on more on that once we get through kind of just a little bit more discussion on the other states. And I'll go through these pretty quickly because California is generally the strictest, and all of these states, the way that they really differ from federal law is that they compare more jobs to each other, and they require more of a justification for why there is any differential. So New York, very similar to California, and and it also has a explicit pay transparency requirement like I touched on before. Maryland, again, has a very similar law to California. It's actually potentially even broader than California in terms of the types of jobs that it's going to compare to each other. And then Massachusetts also has a very similar law. Although Massachusetts even goes a step further and prohibits employers from even requesting or requiring applicants to disclose prior wages. So what do you all need to do as employers? So the practical advice is make sure that you review your handbooks and policies to make sure that any reference to compensation does not prohibit employees from discussing their compensation with other employees. Now that doesn't mean that you have to disclose other employees' salary information. Employees are free to ask their employers or other employees what their salaries are, but you don't need to give them that information. You just can't take any adverse action against them for asking. So just remind supervisors of that, because I think that has been a long rule kind of in the workplace that you just don't discuss pay. That's just not what's done. But so, I think that a lot of supervisors may have that in their head. It's very important to make sure that supervisors are aware of these new legal requirements. So in terms of how do you make sure that your compensation is equal among the sexes, it's important to train decision makers who make compensation decisions about the law's requirements, and then also consider the law's requirements when you're making any changes to compensation policies. And then in terms of how you can work with your job descriptions, make sure that your job descriptions are detailed and updated. And if they are actually, if there are two jobs who are really different but are operating under the same job description, that can be an issue if an equal pay issue ever comes up. So make sure that your job descriptions are updated and actually differentiate when there are different jobs being performed. And then lastly, as Kai mentioned, conduct a privileged audit to determine potential problems. So a company like Salesforce has money to throw around, and so they might commit publicly to running an audit and fixing any pay issues. But most employers, you just can't afford to commit to the public ahead of time that you're going to fix every issue. And there may be some individualized places where you might decide for whatever business reason that you just can't fix that issue right now. So it's important for the audit to be privileged, to work with counsel on that, to make sure that if you make that sort of decision, that's not going to come back to bite you later. And when you're looking at whether a position is similar to another one, it's important to look at it from an outsider's perspective. I think that's really hard for most employers because obviously you understand your organization really well, but think about it from the perspective of a jury or a judge or just someone looking at your organization from the outside, and whether they would really believe that these two roles are truly different, or when you look at them side by side, if you compare skill and responsibility, etc., or do they really belong in the same bucket pay-wise? Oh, and lastly, be sure to include all forms of compensation when you're looking at whether folks are paid equally, because there can be discrimination even if folks are paid the same salary in the bonuses awarded and things like that.
Okay. All right. So I'm going to talk about the new Trump administration. What's in store for employers now? So it's been 100 days, and there's been a lot of news about it's 100 days, and it's fake news, fake sort of delineation. But I want to talk about the Supreme Court. Basically, obviously, Trump, we know he's appointed Judge Neil Gorsuch to the Supreme Court. That was confirmed. We'll briefly mention the EEOC, the NLRB, the Department of Labor, the status of the Affordable Care Act, which is really, we don't know, his maternity leave, which again, we don't really know, minimum wage, and then immigration. Okay, so earlier, it was funny actually, preparing these slides for Mac was like, this is your deadline, it's middle of April, and at that point, the first deadline, Neil Gorsuch hadn't yet been confirmed. But then Mac moved the deadline for our slides 1 week, and within that week, Gorsuch got confirmed. I think we all know the Republicans, they opted the nuclear option, so where in order to get confirmation past a filibuster, you only need a majority vote, 51 votes compared to 60. So Gorsuch was appointed. He's been confirmed. He's filling the spot previously held by Scalia. And so what do we know about Gorsuch? He is similar to Scalia in that he is an originalist. He believes in applying the law as it was originally drafted. The focus is looking backwards, not forwards. You're looking at the structure and the history to decide what the reasonable reader at the time of when the law was passed, basically, and not to decide cases based on policy consequences that may serve society best, like now, given the present day.
So, for example, he would say that Title VII at the time was not, we anticipate that he would say that Title VII at the time was not intended to cover sexual orientation, and so it should not now.
Right. Although I have to say it's always hard when Supreme Court justices get confirmed into the Supreme Court, people anticipate what they would do, and often they don't necessarily always behave the way people are expecting. So I'll give them the benefit of the doubt until it comes down. All right. A couple of really sort of publicly significant decisions that Gorsuch participated in when he was a 10th Circuit judge. One is Hobby Lobby, and the other is Little Sisters of the Poor. And both of these concern the Religious Freedom Restoration Act. And in Hobby Lobby, the issue, it was under the Affordable Care Act and the mandate that companies must pay, the health care plan must cover the contraceptive costs. And Hobby Lobby basically argued that under the Religious Freedom Act, that they should, because they don't believe for religious reasons in providing contraception, their health care benefit plan should not be required to comply with the Affordable Care Act. They shouldn't have to pay the contraception for their employees. And Gorsuch agreed. He said that it's important to protect these unpopular religious beliefs, and it's vindicating the nation's long-held aspiration to serve as a refuge of religious tolerance. Similarly, in Little Sisters of the Poor, he was involved. He authored a dissent from a denial to rehear a similar challenge brought by a nonprofit order of nuns. Okay. The other significant decision that people are looking at to try to figure out how Gorsuch is going to behave once he's on now that he's on the Supreme Court, is Gutierrez-Brazula versus Lynch. And this was an immigration case. And this is sort of incomprehensible, but this slide. But basically the idea is that the administrative agency that was in charge of this law interpreted the law, and the majority decision, sort of, they upheld the administrative agency's interpretation of the law. And Gorsuch dissented from that, and he basically said, no, the courts are responsible for interpreting the law, and we should not defer to administrative agencies. So, for example, in the Hively case, the EEOC had issued 2 decisions prior to the Seventh Circuit's decision, basically saying Title VII, the EEOC's interpretation of Title VII is that Title VII protects against sexual orientation and gender identity discrimination. And the judges in the Seventh Circuit, when they issued their en banc decision, they looked to the EEOC's interpretation, and they let that EEOC interpretation guide them in their interpretation of Title VII. So arguably, Gorsuch would say it's not the EEOC's role to interpret the law, it's the judge's role, and that the courts should have the authority to interpret statute, not the administrative agency. All right, so before we started the presentation, I asked for a show of hands of who has arbitration agreements signed with their employees. So this, let me see if I can explain this. So one of the decisions that's has gone up to the Supreme Court, that the Supreme Court is going to settle, is the issue of whether or not arbitration agreements can require employees to waive their right to pursue a class action. And the situation is that the NLRB, the National Labor Relations Board, which we typically know of as governing union employees, and people may be asking, well, why do we care about the NLRB? We don't have a unionized workforce. Well, the NLRB issues decisions and gets involved in litigation that affects, as Lisa said, your non-union workforce. And in one of the areas where the NLRB has gotten very involved is in evaluating the legality or the validity of arbitration agreements. And the NLRB has decided that arbitration agreements where employees waive their right to a class action, that violates their right to collectively bargain. And it violates the National Labor Relations Act. And so that is an issue that's going to be decided by the Supreme Court, probably in this next session. Okay, so composition of the EEOC. The point of the slide is just that Trump is going to be appointing members of the EEOC as well as the EEOC General Counsel. And under the Obama administration, Obama sort of gave the EEOC a sort of a mandate to be very empowered and be very active and actively litigate issues that fall under their jurisdiction. I think we can easily say that under the Trump administration, those powers and that mandate is going to be retracted. The NLRB, the board has 5 members. There are 2 current vacancies. We expect Trump is going to be appointing individuals to the NLRB. And like we said, the NLRB has decided that class action waivers and arbitrations are a violation of employees' right to collectively bargain. So it's hard to say actually what the Trump administration's effect on the NLRB will be, but we anticipate it's going to become much more pro-business, which is kind of a contradiction in terms, but we'll see what happens. And then the U.S. Department of Labor, Alexander Acosta was just appointed, I think it was Thursday or Friday last week. Mm-hmm. So his appointment went through pretty smoothly. There wasn't a whole lot of press or publicity about it, but we do know that he's pretty conservative. And so we expect for the Department of Labor, it will take a more sort of business-friendly slant. Okay. The Affordable Care Act, we know that sort of the Republican plan of the repeal and replace didn't work towards the end of March this year. And there's been a lot of chatter about how they're going to bring in a new plan. It's going to be even better. It's not really clear what Trump's sort of path to victory is to repeal and replace it, because with any changes that appease the Freedom Caucus members of the Republican Party will alienate moderate members of the House. So it's hard to say where that's going to end up. Right now, Obamacare is still going. All right. Trump's plan for maternity leave. So when Trump was running for president, he ran on a platform to basically provide paid maternity leave for around 6 weeks to biological mothers who were having children. So it didn't apply to fathers during his campaign, and it did not apply to people who adopt children. It's unclear, I think recently in March, he made some kind of speech, and he referred to it as a Family Leave Act instead of just a Maternity Leave Act. So we don't actually know at this stage where he is with this or what kind of Maternity Leave Act or Paid Parental Leave Act he would pass. All right, this is the future of minimum wage. So in 2016, the Department of Labor issued a new white-collar exemption, raising the exempt salary threshold to 47,000, almost 500 a year. Okay. The federal district court in Texas granted a preliminary injunction, basically barred this legislation from going forward. And that was, it was scheduled to take place in December 2016, and it was like late November when the federal district court basically shut it down. And so that at the time, the Department of Labor under the Obama administration, they appealed the judge's order to the Fifth Circuit Court of Appeals. And during the Obama administration, they were pushing for expedited briefing on this issue to try to get the issue decided before the Trump administration came in. The Trump administration came in, and the DOL now is taking the position of delay, 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 delay. So they've pushed the briefing out, they've pushed out oral arguments. The new Secretary of Labor, Acosta, this is going to be one of his sort of first major decisions, and we expect that this legislation is going to die, and that the exempt salary threshold will not be raised to 47,000. Okay, so what does that mean, right? It basically means, what I think it means, and we have a California minimum wage slide, but the idea is that I think that it's going to be on the state level, with states increasing their state minimum wage, and then organizations with operations in different states having to comply with different states' minimum wage laws, and making sure that your employees at the different states are all properly getting the right salary threshold that complies with that particular state minimum wage. Like, so for example, California is going to go up to $15 an hour in 2023 or 2022. This is Sample Bay area minimum wages. But the legal effect of California's state overtime exemption is that the salary exemption for white-collar employees in California, that is going to increase in accordance with California state minimum wage, right? So the point is just that make sure that you're keeping up with your state minimum wage, that you're watching your exempt employees, you're watching their salaries, and you're doing whatever your particular state requires in order to keep your exempt employees exempt, keep their salaries exempt, all right? And that's it. Sorry, this is all more about different states. Okay, and then the immigration. I have a bunch of slides about the Trump and immigration, but I think the main point here, well, does anybody here have employees under the H-1B program? Oh, you guys do. Okay, I'll just talk about it briefly then. So Trump recently signed an executive order targeting the H-1B program. Right? He went to Snap-on Tools, I think it was in Wisconsin. He made a big deal, had to sign this executive order that affects a lot of companies around the country, especially in the tech industry. So I thought it was a little ironic that he was at Snap-on and not out here in Silicon Valley to do it. But so basically, the idea is his executive order is just for a multi-agency report to do an sort of evaluation or investigation of the program. And one potential change is to change the lottery system to give extra preference to the highest paying jobs and give priority to potentially highly skilled workers. The argument right now among at least the tech sector is that the lottery system enables a lot of these technology outsourcing companies to bring in a lot of temps from overseas, and they're not actually placing employees in specific targeted positions. They're just like they're applying under the lottery to get a lot of like workers they can come in and send in on a temporary basis. So actually the tech sector is cautiously optimistic about this potential change to the H-1B program. I think we all know, so far Trump has tried twice to ban the entry of Muslims entering the United States via executive order. The latest one has been blocked by a federal judge in Hawaii And the Ninth Circuit is going to hear oral arguments on this actually on May 15. It's coming up in a couple weeks, next week. Okay, the practical future of immigration, this is actually the point that I wanted to make. So Trump right now, he's been doing a lot of deportation of individuals, and that's in the news a lot, right? He's deporting many, many individuals to Mexico, regardless of whether or not they came from Mexico. He's deporting illegal or people who don't have the proper paperwork. What we do see, and he hasn't started going to employers and doing audits and forcing employers to deport or fire their individuals who don't have the proper I-9 paperwork, but we think that that is definitely coming, okay? So our recommendation to employers is to do a self-audit and go through all your I-9 paperwork and make sure you have all the paperwork for your employees. You're not obligated to kind of know when something's fake or when something's not, except if it's blatantly fake, like where anybody would know, you should probably ask for new paperwork. Does that make sense? Okay, like I have an example. I had a hotel client. They had it was a sex harassment case involving a plaintiff. She was clearly Latino. We needed a Spanish interpreter at her deposition, and her name was like Mary O'Malley in her I-9. So she had a very, very traditional Irish name, and she was very obviously not Irish. So I would say that's something that's very blatant. You would ask your employee for, well, why don't you give me your paperwork, better paperwork, something. Okay.
All right. So this is not necessarily within the name of the presentation, but as Kai mentioned at the beginning, this is somewhere where we just see so many issues arise. And I would say, as I mentioned, I spend a lot of my time doing advice and counseling work, and I would say probably 50% of the questions that I deal with or the situations that I deal with have to do with disability and accommodation and leave issues. So just talking about federal law, the Americans with Disabilities Act applies to any employers who have 15 or more employees. But just be aware that state laws sometimes apply to even smaller organizations. So for example, in California, the California disability discrimination law applies to employers with 5 or more employees. And it applies to individuals with a disability who are qualified and can perform the essential functions of the job with or without a reasonable accommodation. So it covers folks not only who have an actual disability, but who have a record or a history of having a disability, or who are regarded as having a disability. So the ADA not only prohibits discrimination against these folks, but it also requires that employers reasonably accommodate qualified individuals with disabilities unless it poses an undue hardship. And I'll get into more about what all that means. And it also requires you to engage in an interactive process with an employee and possibly an employee's healthcare provider if it appears that they may have a disability that's affecting their ability to perform their job. So one thing to keep in mind is that this is always a highly individualized process, and that's what makes it so difficult, because there's no one-size-fits-all set of rules here. You have to actually talk to the employee and assess the individual employee's situation to determine how to handle any disability or leave question. So this comes up, the most common ways we think of this coming up is the employee comes to you and says, hey, I'm having this issue, I need help. But it can also arise in other ways that I think people, don't necessarily expect. For example, someone might mention something about their work schedule as it relates to a medical condition. Or it often comes up when you're in the middle of counseling or disciplining an employee and they say, oh, you should know I'm late actually because I have this medical condition that's actually affecting my ability to perform the job. So just be aware that it's not only an issue when an employee comes to you and says, I have this condition, I need an accommodation. It can arise in all sorts of ways that you just become aware that an employee is suffering from some sort of condition that impacts their ability to perform their job. So there are as many different types of accommodations as you can possibly imagine, but they kind of generally fall within 3 major categories. And that's ergonomic, which is adjustments to equipment or to workspace. Job changes, such as schedule adjustments, light duty or other task modifications, or leaves of absence. And that last one is one that I think folks forget a lot. So leave as an accommodation. This is something, as I mentioned, that just is not really on folks' radar. That, I think most everyone is familiar with FMLA and the leave requirements under that. But what a lot of employers don't often realize is that if an employee reaches the end of their FMLA or isn't eligible for FMLA, they may still be eligible for leave under the ADA. And a continuation of an FMLA leave may be a reasonable accommodation that's required. So that doesn't mean that you always have to give a leave or that you have to give an indefinite leave. So the key question is the leave reasonable under the circumstances? And the major indication of an unreasonable leave is if it's indefinite. If the employee's doctor can't or won't say that I expect that the employee can return within X months, or if they're just unable to make any sort of prediction about when the employee will be able to return to work. So things to know is that this could apply immediately. An employee could need to go out on leave immediately, and you may not necessarily be able to require a transition period or a waiting period. This can be intermittent leave. They may need a couple of days off a week, for example. And generosity is not the test. It's not whether you're being generous to the individual. It's whether you have looked at this individual's specific circumstances and the medical information that you may have from their doctor and assessed what a reasonable accommodation is under the circumstances. So this is just a quote from the EEOC talking about how employers often forget that what's required is an interactive process. You need to actually talk to your employees, and this may be a long, ongoing conversation about what sort of accommodations they may need. So, what we've learned from litigation, as Kai mentioned, we see litigation on these types of issues all the time. So medical leave may be a reasonable accommodation, and most importantly, I see this all the time, inflexible leave policies, which say if you've been out for a year, you will be terminated, things like that, are a violation of the ADA. And the EEOC has gone after those and gotten millions and millions of dollars from employers. So, one difference that's helpful about the ADA from the FMLA is that the FMLA, there's no argument that there's an undue hardship. There's no argument that operational difficulties don't allow you to grant a leave. If someone qualifies for FMLA, you have to give it to them. Under the ADA, though, leave is just one possible form of reasonable accommodation. So if other accommodations will be effective in allowing the employee to do their job, say, for example, in the instance of the employee who comes in late all the time, maybe you shift their schedule later 1 hour, then you don't have to give them a leave. So this is all part and parcel of the interactive process where you have to talk with them, figure out what their restrictions are, and work together to find an accommodation that will fit everyone's needs. So this is just a quick recap. As I mentioned, you can look at accommodations other than leave. You don't have to provide indefinite leaves, but there's no, as I mentioned, there's no set duration that we can say, well, 1 year is a reasonable amount of leave, 1.5 years is a reasonable amount of leave. It's always going to be an individualized assessment. And so here's another issue that comes up all the time. Employers and organizations say, we just don't allow people to work from home. And I say on the slide here, yes, you do. What I really mean is, yes, you may. You need to consider that. And if there's an operational reason that you can't allow a particular employee to work from home, then that may be a justification for not granting that accommodation. But simply saying we just have a blanket rule, that's not going to be legally sufficient to protect you if you deny that person that accommodation and they sue. So, not everything is a reasonable accommodation, despite how it may feel for some employers. You don't have to change an employee's supervisor. That one comes up all the time where, employees say that their supervisor stresses them out. You don't have to bump another employee from his or her position. You don't have to create a new position. You don't have to eliminate the essential functions of the job. And there are a number of other things that you don't have to do. When you are working with an employee in the interactive process, make sure that they understand the consequences of failing to comply with it. So in this case here, it was a Sixth Circuit case in 2014. A long-term employee failed to return leave paperwork on time and was terminated. But the court found that because the company didn't make sure that the employee understood the consequences of failing to return that paperwork, that they had violated the law in that termination. So make sure that when you are working with an employee who is going to be out on leave or who is engaging in the accommodation process, that they understand what will happen if they don't participate in it and if they don't follow the timing rules. So another little piece of details is another court found that simply dropping a notice to an employee in the mail was insufficient to demonstrate that the employee actually received it. So when you are sending your employees FMLA notices, things like that, make sure that you are using trackable, traceable methods so that if need be, you can demonstrate that your employees received it. And these are just more common FMLA and ADA pitfalls. So I can't tell you how often I see employers who say, well, or supervisors more frequently, who say, they can come back to work once they have a full duty release or a release without restrictions. That's a violation of the law. You can't mandate that someone doesn't have any restrictions when they come back. So basically what needs to happen is if someone has restrictions that might allow them to come back to work, you assess those restrictions, you determine whether a reasonable accommodation can be made that will allow them to return to work. It's an individualized assessment once again. Again, we don't do that here. That's just another type of kind of blanket rule that is never going to be sufficient to show that you've met your burden in terms of working with an employee on an accommodation issue. And so what about the undue hardship? That's an issue that arises a lot where employers and organizations say, well, it says right here that if an accommodation is an undue hardship, then I don't have to grant it. But what an undue hardship is a little bit more strict than you would think from just undue hardship. So when a court or the EEOC or whoever is looking at an undue hardship, they look at the nature and costs of the proposed accommodation, the overall financial resources of the organization, the number of individuals employed, the effect the accommodation would have on the resources of the organization, and the impact the accommodation would have on the organization. So what that really means fundamentally in practice is the more resources you have, the more well-off your organization is, the bigger your organization is, the harder it is to justify any denial of an accommodation as an undue hardship. So, bottom line, if you need additional medical information from employees in order to assess whether you can provide a certain accommodation, don't be afraid to request that. But the real bottom line is engage in the interactive process. It's interactive. You need to talk to your employees. You can't just send them paperwork, get it back, and never talk to them and really truly have complied with your obligations. And with that, I don't know if we have time for questions. Questions in the room? Okay. Sure.
How does the ADA affect the State of California disability leaves?
Sure. So California. In California, you are more often following California law. And it is more strict in some particular areas. And sorry, the question was how does the ADA affect California leave issues? So you may have more stringent requirements on things like the interactive process. And California provides a number of leaves in addition to FMLA. Is there any particular aspect that you're wondering about?
You talked about intermittent leave.
Yes.
When you have an accommodation where there's an intermittent leave, how does that affect the pay?
I see.
Is it justified for an employer to say, well, if you're only working 2 days a week, I have to reduce your pay. But
Sure.
I have to bring somebody else in to replace you when you're not here.
Sure. So the question was, if you have an employee on intermittent leave, how does that affect the your ability to pay that employee? And so it depends, right? Is this an hourly employee or a salaried employee? If it's an hourly employee, you don't have to pay them for hours that they're not working. If it's a salaried employee, if they work during that week, then you should not reduce their salary.
Wow.
Usually.
So this problem with salaried employees is you don't want, let's say you have a salaried employee who can only work 2 days a week, you actually don't want to reduce their pay or prorate their salary so they get 2 days of pay, because then they have an argument that they're misclassified as exempt because now you're paying them like an hourly employee.
What happens if they've used all of their sick time and their personal time and they're not fulfilling the responsibilities of their duty?
Right. So I think you would have them, I think you would apply for partial state disability and you would pay them apart, except you would want to think about what they do when they come in for the 2 days a week and give them, instead of literally prorating them like on the hour, kind of say that it's tied to like the job duties that they are doing, it's kind of valued at this. So maybe you pay them 50% or something like that.
So the important part is just not to tie it to the specific hours that they're working. You can say that they might be working 50% of their job, but you never want to tie a exempt employee's salary to the hours that they're working, the specific hours.
Right.
But under FMLA,
Mm-hmm.
it allows you to change that. I mean,
Right.
it's quality or quantity, but
Right.
so I think it's different under ADA than it is
Right.
FMLA.
The question is it's the pay is different. The proportional pay is the rules are different if you're under the FMLA versus if it's just an ADA leave. Right.
Question?
So my question has to go back to the whole minimum wage and exempt, non-exempt, but it sort of ties into her thing with the leave of absence, because if someone's exempt and you put them down to 50% and they don't meet that qualification anymore for being exempt, then you have to make them hourly, correct or no?
No, but because if they're exempt but they're only working part-time, so
But how I read the law was that if they don't make that
Salary.
minimum salary,
Time.
Yeah.
no matter whether they're 50% or 100%.
That's
they
right.
have
So
to be-
the question is about if you reduce someone's salary because they're on a leave, how does that affect your ability to maintain their exempt status? Because part of the exempt status is meeting a minimum salary amount. And I think that's right. I mean, I think that is a matter of risk balancing, right? I think that it's right that it is a risk that someone could claim that they were misclassified because they didn't meet the salary portion of the exemption. But I think that that's a risk probably a lot of organizations choose to take rather than reclassify folks back and forth.
Okay, so then going back to that though, you said that probably the new federal levels may not ever happen?
correct. We think it's going to die.
Should we just go by the state?
Yeah.
That's already enacted, you have to go by
Yeah.
the state.
Right.
So
You
the
have to
question-
go by the state now, except the federal level was actually going to raise it
Yeah, so
above
we did the
California.
federal just because we didn't want to change twice.
Right,
Right.
right.
And so now we can sort of go back to the state.
Well, you're going to have morale issues if you do that.
It was
Because
so
we make
intense.
people exempt.
Yeah.
Oh,
It
yeah.
We've had to make non-exempt.
Yes.
And then what about teacher exemptions? Because I know with some of the new stuff that was coming out, the teacher exemption was going away. Do you know anything about that?
I don't offhand,
don't.
but we can look into it and get back to you.
Yeah, yeah.
I mean, but so just to recap, the question was about kind of what the kind of status of the federal rules are. And so as Kai mentioned, everyone really expected that these new exemption rules would go into effect December of this year. And then and so many employers prepared to make the changes, actually made the changes, communicated the changes. And then a week or two before they were actually due to go into effect, there was just this halt on them. And so, unfortunately, we would not be surprised to see them not get pushed through in the foreseeable future. Right. And so that means that you're still complying mostly with state requirements, particularly in California.
Yeah.
I have to end it there. Almost 2 years.
All right.
Okay. One more question. Do we have time for one more?
How legal will be to recategorize the employee from exempt to non-exempt on that? Under the ADA leave.
Oh.
Sorry, what was the question?
Sorry, I don't have a mic. The question was, if you recategorize an employee from exempt to non-exempt when they're taking an ADA leave, and whether that's permissible.
I don't know. Do you know?
I don't know off the top of my head. I mean, generally, if you are maintaining an employee's kind of same pay rate, the standard is that you can't, retaliate against an employee or discriminate against an employee for a disability. So generally, if you are maintaining kind of their same normal level of pay for the same general amount of time of work, there would be an argument that you're not discriminating against them. But I don't know off the top of my head, and that's frankly just not something that we see come up a whole lot.
Right. I think it's a little tricky, though, because I think an employee could argue that you're retaliating against them for taking leave by demoting them into a non-exempt position, because exempt positions are viewed as, more prestigious and you have more authority compared to a non-exempt position. So you're kind of in a catch-22. Employers are in a catch-22 there. So.
All right, guys. Well, thank you very much, Lisa and Kai.